All right, we're going into number 9, which is talking about COVID-19 federal legislation, and we are very, very fortunate today to have with us not only our chamber legal counsel with a law firm, and he is president also, by the way, as we know, of GableGotwals, Mr. John Dale. And John, I'm going to ask you to introduce your two colleagues, both of whom have helped us in the past. I think it was about a year or two ago at this time on the subject of what now seems very inconsequential of medical marijuana. Now we're on something a little more serious. So, John, if you'll introduce your colleagues and take it away.
Sure, thanks, Roger. So I've got two partners, Chris Thretchley, who's with our Labor and Employment Group, and James Sears, who's in our Tax Group. I believe both of them are on, and I'll turn it over to them.
Good afternoon. This is Chris Thretchley, and Monique, if you would advance the slides for us, please, that'd be great. Thank you. Another slide forward. All right, so on March 18th, President Trump signed the Family's First Coronavirus Response Act. This act is going to take effect April 2nd, and it sunsets on December 31. It covers all employers that have fewer than 500 employees. And the two main things that it does is it requires covered employers to grant FMLA leave for eligible employees who are unable to work or telework due to the closure of schools or the closure of childcare facilities for them. It also grants up to 80 hours of emergency paid sick leave. And then to pay for that, it provides certain tax benefits that my partner James is going to get into. So let's dive quickly into a little bit of the details about these two other components. Next slide. Thank you. So what we're going to cover quickly are some of the details about the Emergency Family and Medical Leave Expansion Act, which was a component of the Coronavirus Response Act, and then the Emergency Paid Sick Leave Act. And then James will get into the tax credits, and then we'll quickly hit on some recommended next steps for employers. Next. Okay, so who's covered? As we mentioned, if you've got fewer than 500 employees, you're covered by these two new laws. Now, the Department of Labor has been granted authority to exempt employers that have fewer than 50 employees in circumstances where compliance with the act would jeopardize the viability of the business as a going concern. So that's going to create a little bit of gray space, but the Department of Labor is supposed to come in within the next couple of weeks, hopefully, to provide some clarity on that. One important piece to the act is that it exempts from civil action employers that have fewer than 50 employees. So that's going to be a big help. Next slide. So which employees are entitled to the expanded FMLA leave? Well, employees who've been employed for at least 30 days. That's a departure from the Family Medical Leave Act. And so it provides, as its title suggests, expanded coverage for employees. So any employee that's been with the employer for at least 30 days is eligible for the expanded FMLA leave. There are exceptions that the Department of Labor is supposed to address regarding healthcare providers and emergency responders who are going to be needed as essential workers. Next slide. I think we may have accidentally skipped a slide there. Yeah, so when can it be taken? So anytime, obviously now we're dealing with school closure. So if school's been closed, or if you have a paid daycare provider who is now closed, then and you're unable to work or telework because you have to provide that care, then you're able to use the expanded family medical leave. But it's important that it actually be either school or paid daycare. All right, next slide. There you go. Thank you very much. So how are employers going to, what are their obligations regarding whether or not this expanded FMLA leave is paid? Well, the first 10 days of the expanded FMLA leave may be unpaid It's up to the employee to choose whether or not they want to use, if they have any accrued paid time off benefits, it's up to them whether they choose to use that. And they could ultimately use the emergency paid leave that's part of the act. But after the first 10 days, then the employee has to be paid no less than 2/3 of their regular rate of pay, up to a cap of 200 per day, or 10,000 in the aggregate, which basically turns out to be about 50 days worth of paid leave. Next slide. So as most of you who are subject to FMLA know, FMLA provides for job restoration rights when the FMLA leave expires. It's similar here with the expanded FMLA leave for childcare. When the employee, when the need for leave expires, then you have to restore the employee to the same or substantially equivalent position with the same or substantially equivalent pay and benefits, unless you have fewer than 25 employees. And then there's about 4 different conditions that have to be met in order for you to be exempt from the restoration obligation if you have less than 25 employees. So next slide. So on the Emergency Paid Sick Leave Act side of the coronavirus response legislation, it too covers employers with less than 500 employees. It also provides a potential exemption that the Department of Labor is going to clarify that would exempt small businesses from having to comply if it would jeopardize their viability. Now here, any employee, full-time or part-time, is eligible to use the emergency paid sick leave. Next slide. So this slide captures the reasons when emergency paid sick leave can be used. Again, this takes effect April 2nd. But if you'd like a list of these, we can send out an alert that has this list, unless Monique's going to send out, well, you do have the slides that go with these. So, but if they need to self-isolate or self-quarantine pursuant to a federal, state, or local order, then that would be a covered reason for emergency paid sick leave. If they're going to self-quarantine because a healthcare provider has provided that recommendation, then that would be a basis for use. If they're experiencing symptoms of COVID-19 and they're going to seek a diagnosis, then when those conditions are met, they can use it. If they're going to care for a quarantined family member, they can use the emergency paid sick leave. And then if they're taking off because of school closing or daycare closing, they can use it as well. And then the Department of Labor is authorized to add any other substantially similar conditions if it elects to do so. Next slide. So how much sick leave has to be granted? It's up to 80 hours for a full-time employee. Part-time employees can take hours, the average hours that they would work in a 2-week period. So you just look back 2 weeks, average their time up. That's how much emergency paid sick leave they can take. It doesn't carry forward into the next year. Again, it's part of the sunset. And the amount that you have to pay for that is capped depending on the reason why they take the emergency sick leave. Next slide. So probably because of the haste with which this legislation was passed, it appears that there's a little bit of a wrinkle in it. The emergency paid sick leave has an anti-discrimination, anti-retaliation component to it. It prohibits employers from discharging, disciplining, or otherwise discriminating against an employee who takes the emergency sick leave or files a complaint in regard to the use of paid sick leave. There is no such prohibition on the expanded FMLA leave side, but it would still be risky to engage in any of those kinds of actions with somebody who attempts to exercise the expanded FMLA leave. The next slide. My colleague James is going to get into the tax credits here.
Sure. So thanks for having me. I hope you can hear me. Chris covered, when do employers have to pay sick leave, pay FMLA leave. I'm covering how this is actually going to be paid for by the employers. So generally, employers are required to pay either the expanded FMLA leave or the sick leave are allowed refundable tax credits. Technically, this is against the employer's share of Social Security taxes. I'm going to talk about what the statute says, and then I'm also going to talk about some interim guidance we got Friday night from IRS, which is actually very favorable. It's going to make this easier for employers. But so technically, the statute says the credits are against the employer's share of Social Security taxes. The credits generally equal 100% of the amounts paid, but there are caps to the amount of credits available. And those caps are dependent upon the type of leave being paid and also the reason for the leave. So I've included the caps here in the slides. So for sick leave, if the employee, it's one of the, I think the 3 reasons Chris had in his slides earlier at the first 3 reasons. So if they're either under quarantine or they have symptoms of the disease and are seeking a diagnosis, the cap is up to $511 a day for up to 10 days. So that comes out obviously to $51.10 per employee. And if you'll go to the next slide, please. Then also for sick leave, for the other reason that sick leave could be paid. So this is basically caring for a family member, whether that's a family member that has the disease or a child that their school is closed or daycare is closed. The cap is $200 a day for up to 10 days, so that comes out to $2,000 per employee. And then for FMLA leave, the cap is $200 a day or $10,000 per employee in the aggregate, and that's based on the up to 50 days of FMLA leave that's available. So I put the note in here that there will be additional guidance to come. That is still true. However, after I put these slides together, IRS, Department of Treasury, Department of Labor released some joint interim guidance late Friday night talking about the credits, and they basically have interpreted this as a pretty favorable. I mean, the spirit of the rules here are that employers net will not be out of pocket to pay the sick leave or FMLA leave. Technically, again, the statute says the credits are only available against Social Security taxes, employer share Social Security tax, and that to the extent there's any excess, there would be a refund available. But that's not great, right? Because you can envision situations where you got employers required to pay this leave, and the amounts that they're required to pay are going to exceed their share of Social Security tax, and they may be stuck waiting for a while to get their refund. So that's not good. So what this interim guidance says is actually that, first of all, there will be additional guidance, and I expect it's going to be a lot more lengthy than what we have right now. What we have is about 4 pages, but it is helpful. And what it says is that employers can actually retain all payroll taxes with respect to all employees to cover sick leave or FMLA leave that they're required to pay. If you're familiar with payroll taxes, this not only includes the employer share of Social Security taxes, but it also includes withheld income taxes. It also includes the employee's share of Social Security and Medicare taxes, and then the employer's share of Social Security and Medicare taxes. So the point there is that there's going to be a bigger pot of money available to employers that would otherwise be making deposits with the IRS. They're going to be able to pay the leave out of those amounts. And then the guidance also says, which is also, it's very helpful, it says that to the extent the employer would still net be out of pocket, in other words, they would have to pay more leave than the payroll taxes could cover. There's going to be a special process that the employer can take a new form to file with the IRS to request the refund. And the IRS says that it expects that it will be able to process these requests within 2 weeks or less. So that's very good. And then finally, the statute has kind of a weird piece to it. It said that costs incurred by the employer to keep an employee on the group health plan could also increase the amount of the credits. But the statute directs Treasury to implement guidance as to how to calculate that. And this interim guidance says that they're going to address that in future guidance, which is to come this week. But the point there is that the credits will actually increase to the extent the employer can and chooses to keep these employees on their group health plan. So finally, let's see, I've noted here that certain governmental employers don't qualify. The point there is the statute says that U.S. government, state governments, agencies, and instrumentalities don't qualify for the credits. And then finally, there's no double benefit allowed. So there's some other credits available for certain FMLA leave that's paid for employers. And the statute just says, you know, to the extent you're paying this new FMLA leave and getting credits under this other provision, you're not entitled to these new tax credits. So I think that's all I had. We're certainly looking for the additional guidance to come. It's supposed to come this week, and I expect that it will flesh this out even more. But the big takeaway is that, yes, there's this requirement for these employers to pay, additional amounts of leave, but the employers are not going to be net out of pocket to pay that leave. And the IRS is really interpreting this in an employer favorable way, allowing them to retain any and all payroll tax that would otherwise be paid over to the IRS to satisfy these leave payments.
James, Chris, and John, we can't thank you enough. Gable has been so helpful to chamber members, and by my rough mental calculations, I think there's probably somewhere between 15 and 18,000 employees represented by the business leaders on this call. So again, your good, up-to-date information is great. And if I might comment, the bottom of your slides, how clever of GableGotwals to create your own little slide format with the beautiful coronavirus at the bottom. So very, very sharp. I would, and by the way, would also say, I know there's a lot of us who are getting a lot of tough questions from employees, and the Chamber will continue to work with Gable as our legal counsel in helping facilitate the dissemination of good information, questions from employees who are feeling okay, but in my case, a technician who doesn't feel comfortable walking into a medical facility or somebody's home or something like that, and what do we do about that? And it makes a lot of interesting things. So keep those questions coming and filtering through.